welcome to GHEX 2020. It's a real privilege to be invited to speak to you for a few moments today about home education in the Republic of Ireland. My name is Catherine Sunshine. I am a British wife and mother, and I home educate my three gorgeous children here in Ireland. I have studied law at university in Dublin, and I have had first-hand experience of navigating the legalities of home educating within the state. Now let's go back to the very beginning. Article 42 of the Irish Constitution provides parents with a constitutional right to home educate their children, and up until relatively recently, exercising that right was straightforward. You simply didn't send your child to school and you commenced home educating. However, after very little consultation with the home education community, the Education Welfare Act was passed through at the Irish Parliament, and this act provided for the establishment of the NEWB. The NEWB, or the National Educational Welfare Board, was under the authority of the Department of Education, and one of its functions was to create and maintain a register of all children receiving education at home. The Act also provided for the framework of the application and assessment process of home educators. This meant for the first time, parents wishing to lawfully exercise their constitutional right to home educate were first required to make an application to the government seeking permission to do so, and required to undergo an assessment process so as to determine if their child was or was likely to receive a minimum standard of education. In 2013, the Irish National Child Protection Organisation, TUSLA, was created. Section 72 of the Child and Family Agency Act 2013 dissolved the NEWB and conferred its powers and functions to TUSLA. This now meant that the National Child Protection Organisation of Ireland, who primarily dealt with cases of child abuse and neglect, was to oversee home education rather than the Department of Education. At the time and now, many in the home education community feel that such a transition was inappropriate, if not offensive. As to do so somehow suggested that home education was something to be suspicious of, or a possible safeguarding concern, which of course is not the case. Fast forward to 2016, and the time came for me to make an application to register my eldest child as receiving education at home. I submitted my application in accordance with Section 14.4 of the Education Welfare Act to TUSLA, who acknowledged receipt of my application. They responded by stating that I was required to complete their R1 form. I asked them to provide me with a legal basis as to why I must complete this form, as I could not find one myself. They never provided me with a legal basis. My main issue in completing this form was that in doing so I would be giving consent to the Child Protection Agency of Ireland to have unlimited access to my home and my children indefinitely. I declined to complete this form, and as a result, TUSLA refused to process my home education application, thereby inhibiting me from exercising my constitutional right to my child. Subsequently, TUSLA issued us with a school attendance notice as per Section 25.1. This was a legal notice requiring me to send my child to a school of the state's choosing. However, as per Section 17.2b of the aforementioned Act, such a notice cannot be made in cases where an application for registration to home educate has been submitted. Therefore, we were of the opinion that such a notice was void, and non-compliance with this notice would not constitute an offence. Nevertheless, TUSLA sought to prosecute us, and if found guilty, a parent could face a fine of up to £500 and 1 month imprisonment. We were taken to court and prosecuted under Section 25.4 of the Education Welfare Act, alleging that we had failed to cause our child to attend school. We were initially found guilty by the lower court, however we appealed this, and on the 26th of September 2019, the higher court upheld our appeal. The court decided that the R1 form was not a legal requirement. It was not a prerequisite for the application process, and parents were not required to complete it. The court held that our application for registration had been valid all along, and that TUSLA could not refuse to process it. Some 11 months passed, and parents were now free to make applications without the use of the R1 form. It is important to note that Tuzla had no right to appeal the court's decision to a higher court, but they were unwilling to accept the court's decision nevertheless. Here we are in August 2020, and along came SI 330. An SI is a statutory instrument. It's a type of law that isn't passed into being through a process of democratic voting, but rather it is signed into law with the stroke of a minister's pen. This new law enshrined the R1 form into law. As of August 26, 2020, Tuzla will refuse to process any applications that do not contain the full completion of their R1 form. We feel that the government creating this statutory instrument was somehow an attempt to override or circumvent the court's decision. This now means that parents wishing to exercise their constitutional right to home educate in the Republic of Ireland must sign a form which gives the Child Protection Agency unlimited access to your family home and your children indefinitely. We are very concerned that the government is slowly but surely encroaching on people's constitutional right to home educate, and we understand that some of our European friends may feel the same in their own jurisdiction. However, we have not lost hope. We have been consulting with our legal team and other members of the home education community and are confident that there is a case to challenge this statutory instrument. Thank you for listening, and I invite any questions you may have. God bless and enjoy your day.